clear is this?
Yeah.
So, ready for number 2? The Constitution is a contract between the states that created the federal government. It's not an agreement between the feds and the people. That is a temporal impossibility. Because you see, if you look at the timeline of events, the federal government is the creation of the Constitution. You cannot be a party to a contract if you are the product of the contract, because you cannot sign the contract into legal being if you do not exist until it's signed. That's how it works.
Again, it's crazy how simple it ought to be if you consider the Constitution created the federal government. And then people say, oh, the Constitution is agreement between the federal government and the people. Okay, how is the document that created the thing? How is that entity? How does the same entity that the document created create the document? That doesn't make any sense. So, man, and you hear lawyers say that.
Oh, I know. And it's not an agreement between the states and the people. It's not an agreement between the people and the federal government. When you're talking about contracts, the entities, the people who created the contracts are called the parties to the contract. The people are not a party to the constitutional contract. And you know this by one simple fact. I'll give you the quiz question that I give people when I teach. Was the Constitution ratified by popular vote of the people? No. How was the Constitution ratified?
Through the states.
Through the states.
Of the states. Yeah.
9 of the 13 had to ratify to create a legally binding document. If there had been 8, there had been no constitution and there'd been no federal government, right?
Which is why the drafters call it a compact.
Right.
Because it's a contract between
states.
Sovereign governments.
Between sovereign governments. Yeah. Which is the supporting quote that we have for this point that I'm making. And this quote comes from James Madison in 1800 on the report, his report on the Virginia resolutions. He says, consequently, that the ultimate right of the parties to the Constitution, the states, he says, to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or the legislature. Now, what Madison is explaining in this section of his report on the Virginia resolutions is that there is an essential check and balance of the states on the federal government. But that check and balance is essential, not just simply on the president or on Congress, but it's an essential check and balance even on the Supreme Court of the United States.
Paula says you have a bunch of Hoosiers in the chat, so apparently you're popular in Indiana.